The Coin Lady channel is pleased to have you back. Dear everybody, in the case of Ripple XRP v Terraform, SEC is invoked. Following a settlement with the U.S. Securities and Exchange Commission, Terraform Labs is requesting a reduced civil penalty in this case. In its case against the SEC, Ripple's legal team has asked the court to think about the prospect of imposing a suitable civil penalty. On June 13, Ripple's legal team submitted a notice of further power. As stated in the notification, at the U.S. District Court for the Southern District of New York, they referenced a settlement in the Terraform case and claimed the $60 civil penalty was excessive. Before the state of New York's motion was submitted on June 13, a federal judge approved a $4.5 billion deal between the Securities and Exchange Commission, SEC, Terraform Labs, and its co-founder, Duke One. While she has advised the SEC that Ripple pay over $2 billion in disgorgement, prejudgment interest, civil penalties, and other related costs. An amount of no more than $10 million should be imposed, according to the blockchain company. The penalties issued by the SEC in their separate cases against Block 1 Genesis Global Capital and Telegraph were based on claims presented by Ripple attorneys. Unfortunately, the paper was missing key details about the company's revenue. Civil penalties in cases similar to Ripple's have been agreed upon by the SEC and range from 0.6% to 1.8% of the defendant's gross income, as the opponents to Ripple's explained. That pattern works well for Terraform, and there are even more egregious examples where Ripple's counsel has asserted otherwise. On the other hand, a civil penalty seeking by the Securities and Exchange Commission is substantially more than that range. Despite the fact that no one is facing accusations of fraud and no major losses were incurred by the institutional buyers. Thus, Terraform has verified that the court should deny the SEC's request, which is unprecedented and irrational, and that a suitable civil penalty would not exceed $10 million. After nearly 2 weeks of trial in April, a jury found Quan and Terraform guilty of fraud in one of the longest-running cryptocurrency-related judicial cases. In contrast, the blockchain firm Ripple has been suing the Securities and Exchange Commission, SEC, since December 2020, when the SEC first claimed that the company was unregistered and had received money using XRP. The case set a significant precedent in July 2023 when the judge and Elisa Torres determined that the XR point was not a security regarding programmatic sales on exchanges. In order to compete with USDT and USDC, Ripple intends to create a stable coin based on the US dollar. October 2023. At the time, the SEC stated its intention to negotiate possible solutions with the blockchain business, Ripple, and its CEO Brad Garlinghouse and Executive Chair Chris Larsen. The SEC then moved to dismiss its action against them. Judge Torres had scheduled the trial in Ripple v. SEC to begin in April. Nevertheless, he chose to delay the procedure in October 2023, and a new date for its resume has not been announced. Throughout the period in which this piece was printed, the judge's potential trial date decision was unclear. There is a case involving Ripple and the SEC. The ongoing legal dispute has taken a new turn. Responding to Ripple's most recent filings pertaining to the consent judgment, the Securities and Exchange Commission, SEC, of the United States of America is currently involved in that matter. In a post about Ripple vs. C, James K. Flan noted that the Securities and Exchange Commission has addressed the Terraform Labs consent judgment, as mentioned in a previous post by Flan on Exit Ripples. The present situation with ODL Sales Ripple is fraught with suspicion that it is involved in actions strikingly similar to previous violations. The legal landscape involving Ripple's on-demand liquidity levels service is becoming increasingly complex, according to XRP attorney Bill Morgan, who supplied this information due to this ongoing difficulty. Some have claimed that Ripple's present ODL sales practices are too similar to those that violated SEC rules in the past, notwithstanding the SEC's warnings. In order to determine if the sales are in violation of any current regulations, the court does not have complete records. The already challenging matter has taken on even more complexity. A possible appeal from the Securities and Exchange Commission is adding another layer of complexity to the legal discussions surrounding XRP in the SEC. The July summary ruling. The final decision in the case between the SEC and Ripple Labs could be announced in July, according to legal experts. Additionally, SEC has the option to appeal Judge Torres's ruling that the XRP programmatic sales do not constitute security contracts. Due to this persistent lack of clarity, the pro-XRP attorney Fred Rispoli has forecasted that Judge Torres will make a remedy decision by the end of July or the beginning of August, on the 13th, and both sides are on edge because of the potential for further legal twists and turns and the decreased price of XRP due to legal uncertainty. He thinks Judge Torres would hand down a poetic ruling, but Ripple is against penalties above $10 million, and the SEC is pushing for $2 billion in fines and penalties. Ripple and the SEC may yet be able to resolve the issues that the judges and the verdict must consider, even if I noted that the likelihood of a settlement happening right now is low. Regardless of these recent changes, the XRP community maintains its optimism that the appeals court will find a resolution to the matter. There is still some confusion about Judge Ned Byrne's role in this context. Judge Torres could announce a final judgment on remedies and injunctions without addressing the expert witness matter if Risk-Belly Ned Byrne and tourists could have a discussion and conclude that the matter before Ned Byrne does not require a ruling. In contrast, this would almost certainly only happen if the ruling goes in our favor. Whenever anything happens in the cryptocurrency world, you will be the first to know about it. Among the three most noteworthy crypto news items of the last 2 days, Ripple's CEO has chosen the most momentous day for XRP investors. During his recent appearance at XRP Apex 2024, Ripple CEO Brad Garlinghouse addressed the ongoing legal battle between the business and the Securities and Exchange Commission. When asked by Garlinghouse whether the regulatory position regarding Ripple's is improving, he was joined by his colleague, David Schwartz. In response, he said that the resolution of his company's issue with the regulatory body is in sight. Looking back, you could argue that we're nearly at the finish line of that voyage. Executive Officer Garlinghouse went on to state that, in his view, the issue would be resolved by the end of summer, despite the fact that no one can influence when the judge will make her decision. In response to the question of when it would be ready, I mentioned that Garlinghouse had claimed it would be by the end of August and that summer officially ends on September 21st. My apologies, but I am confused. Bitcoin price discussion with the illustrious trader, John Bollinger. Trading advice should not be construed from the data that has been supplied. Any investments made relying on the information presented on this page are not liable for any reason. The video ends there. Support my channel with a like and a subscription. Muchas gracias, depart.